Welcome to Southpod, the first and foremost podcast created to tell the true story of tech innovation in the American South. Southpod is hosted by John Urian and Stanfield Gray and produced by Dig South Tech Media. Dig South Tech Media is the South's tech hub, the place where leading global brands connect with the most scalable startups. Visit us at digsouth.com and follow us on social media at DigSouth. The following episode features Duncan Byers, partner at Patten, Wornam, Hatten, and Diamonstein. Now let's dig into Southpod with Duncan Byers.
Dig Nation, this is Stanfield Gray, your host of Southpod Rise of the Region. Today we welcome attorney Duncan G. Byers, based in Newport News, Virginia. Good morning, Duncan.
Good morning.
How are you feeling today?
I feel great.
Fantastic. And you are with Patten, Wornam, Hatten, and Diamonstein. Did I pronounce that right?
Diamonstein, yeah.
Diamonstein.
Yeah.
Newport News, Virginia, and you're one of our Dig Nation members that joined recently. We're excited to talk to you today, particularly about intellectual property, complex litigation, a side of the business that's very important, especially in technology, software development companies. You have a lot of experience in that area. Tell us a little bit about the firm, the size, your particular, field of concentration. What do you focus on?
We're actually a very well-known firm, both regionally and nationally, in principal part because we've got about half of the firm that for the past number of decades has been focusing on representing the interests of clients who've been affected by asbestos, mesothelioma cases and the like. And that side of the firm has a bunch of very, very experienced litigators. That's not all they do. One of the partners on that side actually was just took part in a successful winning brief in front of the U.S. Supreme Court. So they've got some very, very good people on that side. And I'm part of what we call the business group. And the business group, we do a lot of different things, including complex civil litigation. We've got some partners that do qui-tam cases, which are essentially government whistleblower cases. They're extremely difficult and complicated and take a long time to get to resolution. We have partners that do numerous transactional work, whether it's real estate, commercial real estate, things like that. And I focus on intellectual property and complex litigation, both intellectual property and other complex litigation. I've actually got an antitrust case that I'm running right now down here in Virginia. And I work directly with another one of my partners, Todd Lynn. And Todd has decades of experience working with technology startups and has done a lot of mergers and acquisitions. And so he and I have been working together on doing startups, doing protection for the startups, bringing in investors, and essentially tying the products and the deals together so that people can launch products. And we're really excited about expanding that, especially in this area.
And what do some of those startups look like? Can you tell us a little bit about the industry or the vertical there?
It varies, but a lot of it is driven by the fact that the Hampton Roads area is, as you're probably aware, home to the largest naval base in the world, as well as NASA Langley Research Center and all the DoD research facility spinoffs. So it runs the gamut from, coatings and technologies, things like that. Unmanned aerial vehicle technology, software and algorithm companies that are coming up with new apps and solutions for others existing problems. We're currently working on a project that I'm personally really excited about. I can't give you too many details about it, but it's quite possibly going to be a paradigm shift in terms of clean and renewable energy sources that will allow not just military secure facilities, but eventually, hopefully, homeowners and the like to get completely off the grid and have long-term renewable energy sources. So Todd and I are very, very excited to be working on that.
Yeah, I can imagine that during this pandemic, everyone's spending so much time at home that they are, in some ways, they have a lot of time to kind of ponder and think about their power needs and the bandwidth and the rollout of 5G this fall, and they can look around the house and say, how could I get off the grid more than just solar panels, for example?
Right, but it goes beyond that. As I said, at some point, I'd like to be able to give you some more details about it. Once we sort of finalize everything and get to the point where we can take it public. But the applications are innumerable, including in space technology, providing power supplies that are long-term and stable, along with providing significantly more power than current designs for spacecraft can actually provide. So, hoping to get rid of these giant solar panels, and you get rid of the giant solar panels, you've got more space for cargo, for warm bodies to explore, for scientific equipment and the like. So it's a pretty exciting technology that we're working on now.
Well, yeah, let's dive into that for a second, into the military presence, the DoD relationships that you have. Charleston is in a similar space where we have SPAWAR here, the Space and Weapons Station, and a large DoD presence, Booz Allen Hamilton, Spark, a few other
Right.
companies that kind of grew up in the Charleston area, and then Houston, of course, and then the Space Coast, as it's referred to, and along the Gulf. And then are there, let me back up for a second. So Dig South focuses on connecting scalable startups to leading global brands, helping people find those opportunities. And is this kind of an overlooked area for someone who may not have a military background, but is, an innovative person who's launching a company? Should they be thinking more critically about those opportunities, particularly as we try to compete with Silicon Valley and Boston and New York and other areas for talent, venture capital, all those resources? Do you see some untapped opportunities there with the military presence in the Southeast?
Absolutely. And I'm very familiar with Charleston. I was stationed there for 4 years when we still had a Navy base there that was
Right.
functional. I was on 2 guided missile destroyers out of Charleston, and spent a bunch of time up at the weapons station as well, unloading and offloading weapons I can't tell you about. But anyway, yeah, it's for people that are unfamiliar with the Department of Defense resources and other governmental resources. It's a huge untapped opportunity, and people think of DoD technology and I hate the phrase warfighting capability, but that's what everybody is using these days. So what we would call the sharp end, right? The weapons systems, people working on developing naval rail guns and things like that, missile systems, body armor, but it goes far, far beyond that. The Department of Defense has a broad reach and a broad area of a massive area of interest in infrastructure and the like to support what the missions are. For example, when you just throw around the term forward operating base, right? You think of a bunch of guys sitting in the middle of the desert going out on missions. But what a lot of people don't realize is behind that is a significant amount of technology, including secure communications technology and the like, that ties those bases back to whatever base they're operating out of as an FOB. And all of that comes back to this U.S., to secure facilities where you have the commanders operating from the U.S., running missions overseas through all of these bases and the individuals. And so it has to be backed up by some very, very inventive technology, including uncrackable communication systems, all the way to the Army Corps of Engineers and Navy concerns, significant concern here about coming up with means to mitigate the impact of global warming and sea level rise on the largest naval base in the world. A lot of people don't think about that, but everything that you can think of for changes in the environment and the like that would impact commercial infrastructure has a significant impact on military infrastructure. So it's everything from, personal communications to designing flood control systems to uninterruptible power supplies, you name it. And they're very interested in new cutting edge technology as well. There are billions of dollars out there that are available for people who have new and interesting technology that could be utilized either now or in the future by the Department of Defense. Quite a bit of that's done at places like NASA Langley, but there are still contracts awarded out to small startup companies to do some innovation. And there are some advantages as well. If you have a small company, you can get preferential treatment. If you have a minority run company, you can get special dispensation for getting government contracts. So there's a lot of availability here for that kind of innovation.
So from a very practical standpoint, does it function like, if you're going to commercialize something that's developed by the DoD, does it function like tech transfer and the way the university might commercialize something and partner with various startups on a project?
Yes, except the tech transfer is generally a bit more, it's a bit more restrictive. Usually what you're looking at somebody getting, and this is true with the entirety of government funded research, right? You're usually looking at a situation where the government retains the rights to use and do anything with the technology that they want to, right? Which can create some commercialization heartburn among startups and clients. But the reality is that the government is not in the business of building stuff, right? The government's in the business of getting stuff built for them. And so it rarely do you find a situation where, the government has rights to a piece of technology, say it's in an issued patent, and they take it and run with it outside of the innovators that have the rights in the commercial sector. Usually, as long as the inventors, the innovators, and the company that holds the rights, other than the government, are capable of bringing that to an operational status, whatever that is, they usually stick with that startup, unless, of course, McDonnell Douglas or Grumman or somebody else decides to come in and buy out the startup.
Right. Yeah. One of our members, Sam Havelock, is a Navy SEAL, and he reports to James Hondo Gertz, who's head of acquisitions for the Navy. And he's described it as sort of testing what DARPA develops in other companies, and you're taking pressure testing it to see if there might be a larger acquisition for the entire Navy.
Yeah, I have a very, very good friend of mine who is a retired SEAL. And after he retired, he ended up taking a job with the special warfare community. And that was his job, was to test new innovations in technology that they were using. I don't want to get too far into what he was doing and what he wasn't doing, but that's exactly right. And it's not.
I'm sure they know each other. That's the same thing Sam was doing.
It's a very small community.
So let's back up for a minute. You're an attorney with a master's degree in chemistry from Old Dominion. So how does a scientist then decide to become an attorney? Walk us through that.
Well, first off, in order to be admitted to the patent bar, in order to be a patent attorney, you have to have either a degree in hard science, or you have to have a requisite number of hours that are defined by the patent office in order to qualify. So, if you've got somebody that's an English major and they never got any farther than freshman chemistry, they're not going to meet the qualifications. So you have to have that kind of engineering or science background. It was recently modified to open it up to people in the biological fields as well, but that's part of it. The other part is, I sort of come by it honestly. My granddad was a patent attorney, and he got his degree in chemistry before he went and became an attorney. So it seems sort of natural. But I did a master's degree in chemistry at Old Dominion University, and did primarily some complex electrochemical analysis of trace metals in the environment, studying the effect of things like zinc, cadmium, lead, and copper on organisms in the Chesapeake Bay and the Atlantic Ocean. And frankly, that kind of background, I think, translates very well, especially into things like complex litigation, especially dealing with experts, right? I'm a geek more than anything else, and so I stay on top of advances in pretty much everything: quantum mechanics, space exploration, programming, software innovations, things like that. I do it not just because I enjoy it, but also because that information helps clients. And in some cases, it's helping clients explain to them exactly why they can't get a patent, right? You have to understand the technology in order to be able to do that.
You speak the language and you have deep science background, so you're able to explain that. It's fascinating. So you've argued before the Virginia Supreme Court as well as several U.S. district courts. Is that correct?
And in front of several federal courts of appeals. I have not done the Supreme Court yet, but that's on the bucket list.
Could you share with us maybe some of the most unusual or interesting cases you've represented?
By far, the one that everybody falls back on is a music copyright infringement suit. I represented two small musicians here locally, and the suit was against Universal Music, Sony, big players in the industry, as well as Justin Bieber and Usher. And so we ended up resolving that. We got an adverse decision down here in the district court that we appealed up to the Fourth Circuit. The district court had dismissed the case. We took the appeal up to the Fourth Circuit, and I got it reversed on a unanimous panel decision, which was nice. It was also a lot of fun because in the Fourth Circuit, they don't see a lot of music infringement cases. And so the panel of justices cut off the timers. Normally, when you do an oral argument on appeal, you have a timer, right? You might have, 15 minutes and you reserve, or 15 or 20 minutes, and you reserve a few minutes for rebuttal at the end, but that's it. Even if you're in mid-sentence, the red light comes on, you're done. They turned the lights off, and we actually ran for, I think it was about an hour and a half arguing in front of them. And other than that, my real claim to fame in that case was I managed to sneak Justin Bieber in and out of Hampton Roads and Virginia Beach to do a deposition, and nobody knew he was there.
That was my next question: is if they appeared in court or gave a
We did. I can't. Because of the resolution of the case and standing confidentiality orders, I can't get into detail about what we discussed. I can tell you this, that despite what everybody may think, it was a refreshing and professional and very personable discussion and deposition that we had.
Sure. Well, so here's a question. I'm a musician as well, and I worked in the music business for a long time. And one of the issues I could see in the future, let's extrapolate 50, 100 years from now, projecting into the future, copyright law with respect to not only sampling, but melody, music, it seems like at some point we may just run out of combinations of creativity. And looking, as a historian of music, it started as an oral tradition, of course, before it was captured on wax and vinyl and recorded. And so the tradition was to pass along songs and then kind of create new verses for them. And, before they recorded it, there may have been 100 iterations of that. And then it became part of an industry or a business. Do you think that there'll be some future point where, with the help of, artificial intelligence, that it's just going to be difficult for people to even create something new as a pop song? Is that?
I've heard that argument before, but it's also the same argument that people have made with written word, right? That every story ever invented was made up by William Shakespeare, right? I mean, you hear that argument all the time, and music is certainly, to a certain extent, more limited in that there's a single language, right? And that language is made up of notes and how you combine them. But if you run the math, just looking at it statistically, if you run the math on what would be reasonable and pleasing applications of the combinations of those notes, the number of potential combinations is just massive. I mean, I can't remember. I've seen the number and I can't remember. It's not a Googleplex, but it's a 10 followed by a lot of zeros. So I don't think so. In part because, if you look at the last 30 years, people were saying that with the advent of digital, with the advent of sampling and the like, that there would be nothing new under the sun. But that's proven, number one, not to be true. And it also discounts human innovation, right? Like, for example, there's a seminal case of copyright infringement that revolves simply around the refrain, bow wow wow yippee-o yippee-yay, right? I mean,
yeah, which is an ear candy. I mean, you can't forget it when you hear that.
That's right. It's the earworms that catch you, and there's always innovation. So I don't see that as a problem. I do see a continuing problem with sampling, right? I think there are a lot of people that unintentionally run afoul of accidentally sampling or thinking that they have the rights to something when in fact they don't. I see that quite often. I think the next interesting phase of that, and somewhat in music, but I think the biggest impact is going to be in software development and design, and that's AI. Right? Once we reach the point where you have AI tied into fuzzy logic and some other techniques, that you've got AI that learns and can create things based upon how the AI is set up, that's going to open up a whole new world of legal cases and interpretation. Although the patent office has just, and I haven't had a chance to take a look at it and see if it was an internal directive or interpretation, but the U.S. Patent and Trademark Office just has said that no, an algorithm or an AI is incapable of creating something, right? So from my perspective, it makes sense. Software geeks refuse to agree with me, but the way I look at it is, you build an AI to do certain things. It's constructed under your direction, and yes, it can learn and adjust, but it's the same thing as building a machine that streamlines the manufacturing of sushi, right? That has adjustable portions in it that adjust for changes in the type of rice that you put in it and things like that. That machine is not adjusting and creating something in the way a human being creates, because that functionality was put there by a human. And so
it's following a series of rules of logic and until the singularity occurs, and we can prove that, right?
Yeah. Wait for the singularity. I don't think I'm going to see it in my lifetime. Maybe you'll see it in yours, but I doubt I'll see it in mine.
you envision a future where, let's say, Spotify, you upload a song to Spotify, they have some partnership with ASCAP and VMI, and the AI just tells you right away, sorry, this song has elements that are, under copyright protection, and rejects it, and you can't even upload it.
I'm actually somewhat surprised that we haven't seen that yet, right? I mean, and here's the breakdown, and sort of taking a step back to the cop music infringement case. There's a part of me that is sort of unhappy that we resolved it prior to going all the way through. I was going up on appeal again on an issue with regards to the experts in it, the music experts, because I was utilizing a producer and engineer who has a list of Grammy nominated singles and albums that's 3 pages long, right? Been doing it for decades. And he uses the latest technology so that when a note is played, he can tell you exactly what frequency that note is, right? There's no question. It's an application of technology that's been around a long time. The opposing experts, the experts that the industry has used for decades, are musicologists. And these musicologists, what they do is they listen to it, right? With very expensive headphones, play it on an instrument, usually like a keyboard that they have specially tuned once a week, write down what their interpretation of the note is, and then confirm it by playing it back on the same keyboard that they used to determine what it was in the first place. Meanwhile, I've got a guy that's using technology to tell you exactly what the frequency is, and yet the industry sticks with the musicologists that use the old, I have perfect pitch method. Right. And at least in this case, the court was not going to allow our expert to testify based upon his experience and the technology that he used. So that was a fight that I really wanted to have, right. But the music industry is a slow-moving behemoth. It is. It's one of the reasons why you see bands like Radiohead that have basically told the industry they're going to do what they want to because the industry won't keep up with them. But I am surprised that Spotify and companies like that haven't found somebody who's developed that algorithm that gives you the copyright warning, right? Sure. Yeah. Now, keep in mind with that there is no bright line rule as to what copyright infringement is, right? It's a fuzzy line, and it's a question of substantial similarity, right? What does that mean, right? You can have substantial or striking similarity, but it also has to be an important part of the music, right? You could lift a 3-note progression from a song that occurs one time in the song that nobody would recognize outside the song, and even though it's the exact same 3-note or 3-chord progression, you're likely not to have copyright infringement because it's just not important to the overall work. So, yeah.
Yeah, I can see that. I mean, the music industry, despite all the innovation of the artists, is slow to adapt. When Napster came out, instead of working to build their own Spotify, they started suing customers and fans, essentially. So that created a mess. Well,
their business model is fundamentally flawed and has been for several decades because the majority
make money off the catalog than they do new music because it's already recorded, the costs are there.
Well, and the vast majority of money generated on the music side of it is touring and performing, right? And I don't think that I don't know that was necessarily part of the thought process for bands like the Grateful Dead and Phish, but they realized very quickly on, look, we're a touring band, we're jam bands, record us, we don't care, make whatever tapes you want, pass them around to your friends, and they're going to show up at the concerts and pay for the tickets.
That's the original viral social media.
Absolutely.
Yeah, that's fascinating. So, kind of jumping off of that, Let's talk about startups for a minute. So in the early years, early stage companies moving swiftly. They're making a lot of mistakes and the frenzy to sort of survive and scale. What are a few tips you might give to early stage companies to sort of protect their intellectual property, their copyrights? What should they consider before they get so far down the road they can't correct that mistake?
Well, I think
or it's too expensive to correct that mistake.
Right. An ounce of prevention is worth a pound of cure. Depending upon the funding availability, and it should be made a priority, is not only working on securing your intellectual property, but at the same time working on ensuring that you are not stepping on anybody else's toes, right?
Right.
Spending $5,000 to $10,000 on what we call in the business a freedom to operate opinion, which is a complex and detailed search of the prior art, including issued patents, patent applications, things, what we call a common law search, things that are actually in the world in general, but aren't necessarily protected by patent or copyright that could stand as prior art. You want to make sure that you're putting your money in the right place. And number one, there's no point in spending a lot of money trying to patent something that is inherently unprotectable, because either it's already known, or somebody else already has it, or as with software these days, it's extremely unlikely to actually get a patent. A few years ago, there was a court decision, the Alice Corp case, that essentially gutted the viability of 3/4 of the patents on software in the US. It's extremely hard and difficult, time-consuming, and expensive to get a software patent now. And the Federal Circuit has not helped it because they have a string of decisions that are sort of all over the place, right? So making sure that you talk to somebody like me about what you're doing and coming up with a plan to protect it before you start getting into the public and before you start going and talking to everybody about it and showing demonstrations of it, you need to make sure you understand what the repercussions of that are, right? Same thing on the branding and trademark side, but that's a little bit different discussion. People tend to do that late as well. They don't do the groundwork before they decide what they think their great trademark is going to be. And then 6 months down the road, they've got to spend $50,000 rebranding, right? And on that side, a lot of people have a hard time getting away from being similar to other people, thinking, hey, I'm in the software industry, so I have to have a trademark that sounds software-y, right? I see that all the time, and that's one of the worst things that you can do. Second thing is, and this is something that a lot of people don't stop and think about, when you've got a startup.
Let's stop, pause on that first point for a minute. So why is that a bad idea to try to come up with something software-ish as a brand?
Because the strength of a trademark is built by its use in the marketplace. All right. Okay. Trademark law revolves essentially around how the consuming public views that mark and what association it creates in their mind, right? So when they see a trademark, who do they think of, right? Does it give them the knowledge that they need in order to know what the source of the goods or services are and the quality of them, right? So it's all from the consumer's point of view. So the more unique a trademark is, and the better a job you do marketing it, the more it stands out in the marketplace, right? The best trademarks in the world are what we call arbitrary and fanciful, that don't have any meaning to anything, and it's all driven by what you do in the marketplace. A good example, Exxon, right? Exxon is a nonsense word. I had seen some reports, I'm not sure I believe them or not, that it actually turned out that it's a word in another tribe, in a tribal language somewhere in like the Amazon, but it's an extremely powerful trademark that was nonsense. And those are the most powerful trademarks. They're the ones that don't have any association to begin with. There are some variations on that depending on what field you're talking about. But sort of going back to what the startups do, that's one of the things they need to think about is how they're presenting themselves to the public in terms of what they're doing, what their branding strategy is going to be. The second thing is that it's a very, very fluid and collegial atmosphere at the outset, right? Everybody's buddies, everybody's working towards the same goal. The problem with that is that oftentimes you'll see startups come in and you have one person who, or a team of people who are responsible for bringing to the table what the real value is, the technology, right? Then you've got a group of people that, hey, we're marketers, we're going to help you build up. I have connections with angel investors. And so a lot of other people end up coming into the picture that don't actually have any ownership in what the real value is, right? They're there to help commercialize and monetize it. But in a lot of cases, you'll see real innovators sort of giving away the farm to people, giving them interests, ownership, and control in things that they didn't develop. And they find themselves 5 years down the road, cut completely out of the loop, right? Yeah, it's extremely common, and it's something that we often have a hard time working with clients on because they're like, well, this is my best friend from childhood, and he's going to come in and help me out, so I want to give him 50% of the business.
So that's the operating agreement and the planning the exit strategy at the beginning. All those are essential of that company formation.
Absolutely. And I mean, it can happen to even the big guys, right? Look at what happened to Steve Jobs at Apple.
Yeah.
Steve lost his job, whether he wanted it or not, because he turned over control. So,
our Dignation members who are out there listening today, how would I put this? So it's a two-part question. One, what would you like to share with that group, and what do you have to offer to the community? And then the second part is, what do you need, and what are you looking for from the community as well?
Well, obviously, I'm interested in what the community is doing. Like I said, I'm a geek. I get excited by new stuff that solves problems that people thought were unsolvable. So it feeds that part of me. As a practical matter, it's an extremely good organization for what I and my partners do in terms of expanding our client base and the people that we can actually help, right? I mean, that's what we do for a living.
Right.
I've got an 18-month-old that I need to feed and keep a roof over her head. So, and my wife as well, of course. So, we're in the business of assisting these startups, and their success is our success. The greater success they have, the more wealth they build, the better off we do, and the better our reputation, which helps bring in more clients. In terms of what we can offer, in terms of what I can offer and my partners, one of the things that we're starting to do, and this is one of the reasons why we've sort of started digging in deeper to get more involved with Dig South and some other organizations, is to provide the kind of information that innovators need so that they can think about these things as they're developing technology and as they're thinking about how they want to launch building a prototype and commercializing and going through that process. And so one of the things that we're working on is putting together seminars and the like that are free of charge, that I tend to like sort of roundtable discussions. I will have an outline and we're going to discuss certain topics and the like. But I think that it's more helpful to have interaction with members of the community rather than just stand in front of a display showing a slideshow, right? So that's a significant part of what we have to offer and what we want to start developing is an opportunity for these innovators to spend some face time with me and with Todd and with others discussing these things, so they don't have to come in and slap $1,000 on the table, right? To spend 2 hours or 3 hours with us or whatever it is, and walk away with the same information that we can get to an entire group of people, do it efficiently, and hopefully, knock on wood, when they do decide to move forward, we're the ones they come to. So
I love it. Yeah, that's a perfect segue into our the next series we're launching for Dig Nation members. It's called Dig Cafe, coffee talk with an expert, executive.
oh, cool.
Yeah, so it's going to be more of a roundtable style discussion. We'll have, I'll have a co-host and MC, John Yerian, who will guide it, but essentially we'll show up, with our beverage of choice and have a good conversation. And it'll be more like old school, where we all met together down at, Starbucks or Collective Coffee, your local shop, and
Right.
a little less like a webinar.
Fantastic. I like that. I like that platform. It's a very good platform. It works well for me. Some people aren't comfortable with it. Some people would rather stand up with PowerPoint and not have to talk to people, but
Sure. I think we're all evolving, as we're kind of trapped in the house and thinking through this. So, final question here, like looking into a crystal ball as we come out of the pandemic, and Dig South likes to say, we're going to rise on the rebound. What do you kind of envision a year from now, 2-3 years from now? How will our behaviors change? How will we, do business? Or have we entered this hybrid world permanently, or will we go back to business as usual? What do you think?
I think we've entered the hybrid world permanently. I do. I have been pushing technology for as long as I've been practicing law. I ran my own firm for 12 years or whatever it was, and so I was the one that got to dictate what the technology was. Patten, Wornam, Hatten, and Diamonstein is my second large firm, and at both of them, I've been pushing technology and bringing in things that assist the client and assist us. And so, for example, one of the things that we are going to be implementing in order to help transition into through this time period and into the next time period is making sure that we have technology so that we can meet with clients without having to sit in the same room. Now, for you and I, we have computers, we have tablets, we have the technology to do this. But if you're talking about elderly clients and people that are disabled or the like, that can be difficult. And so what we are doing now is we're coming up with a plan so that the firm is going to incorporate technology. We're going to bring in dedicated tablets and set them up so that we can deliver these to clients as necessary. And I'm going to expand that beyond that, to opposing counsel if necessary, whoever I need to, witnesses, it doesn't matter, so that we can actually do the FaceTime. We can do this exact thing face to face, and it keeps somebody that is, for whatever reason, unable to leave the house and the like. It makes it so that they don't have to adjust their life uncomfortably, and it's very efficient, right? If they can't come to us and spend an hour getting ready and then get in the car, and by the time you do that, you've lost half a day. We run a courier out with a tablet, and there you go. So we're doing that, and I think it's going to be permanent. I do. I also think that there are going to be portions of the industry, not just legal industry, but other industries, that if they fail to recognize that they're going to start losing impact, and they're going to start losing any kind of headway that they've got in the marketplace. I think it's here to stay. Everybody's got phones now. I mean, anybody that's our age and younger that doesn't have the ability to chat on their phone is living in a cave for the most part. So, absolutely, in the U.S.
So today on Southpod, we have welcomed attorney Duncan Byers. And how should people get in touch with you? What's the best way to reach you, Duncan?
Well, they can find me on LinkedIn under Duncan G. Byers. They can find me at pwhd.com. I will tell you, we're in the process of redesigning the website, so have patience when you get there. I can be reached directly at dbyers at pwhd.com. It's dbyers at pwhd.com. So feel free to look me up. And if you have questions, please feel free to send them to me. I'm happy to answer them to the extent that I can. There are some ethical constraints I have to worry about, but that's the best way to get a hold of me.
Thank you for joining us today on Southpod. We look forward to welcoming you to Dig Cafe soon and connecting you deeper into the community.
I look forward to it as well. Thank you.
Thanks. This is Stanfield Gray, host of Southpod, signing off. Thanks for joining us today.